Remember the time when the RTI exposed the Adarsh housing scam, Commonwealth Games corruption, ration distribution fraud, Manrega fund leakages, and even revealed key documents in the 2G spectrum controversy? That wasn't luck. That was the Right to Information Act working exactly as it was meant to. For years, Section 8(1)(j) of the RTI Act allowed something very powerful for the citizens. Even if information was personal, it could still be disclosed if larger public interest demanded it. That single clause helped expose asset mismatches, irregular appointments, conflict of interest, and misuse of public funds. It gave ordinary citizens a lawful way to question power. But now that balance has been shifted. Through Section 44(3) of the Digital Personal Data Protection Act 2023, which amended Section 8(1)(j) of the RTI Act, removing the earlier public interest balancing test for personal information. This amendment is now under direct constitutional challenge in the Supreme Court. On the 16th of February 2026, the court heard petitions questioning whether this change has weakened the RTI framework. The court issued notice to the Union government and referred the matter to a 5-judge constitutional bench for a final consideration. The core question before the court is profound. Can privacy be used as a blanket ground to deny information even when it relates to public activity, public office, or public funds? What does that mean for you? If tomorrow you suspect corruption in a public office and you file an RTI seeking the asset declarations of the public servant you doubt, the response may now be a very simple: this is personal information and disclosure is denied. If you question irregular admission in a government institution, they could just say this also involves personal data and cannot be shared with you. If you ask about conflict of interest in public contracts, they can simply say that this also comes under privacy and is exempt from being shared with you. The law was designed to protect citizens' data, and privacy is a fundamental right under Article 21. But here is the constitutional tension the Supreme Court must now resolve. When privacy shields ordinary citizens, it strengthens democracy. But when privacy shields public power, it can weaken accountability. The petitions argue that the amendment effectively creates a near blanket bar on disclosures of personal information, tilting the balance away from the citizen's right to know. And now the real issue before the constitutional bench is not whether privacy matters. It obviously does. The real issue is that in a constitutional democracy, when public officials handle public money, public offices, and public trust, how much information can now be lawfully denied to the very citizens in whose name that power exists? This is not about politics. It is about constitutional balance between Article 21 and Article 19(1)(a, between privacy and transparency, and ultimately between power and accountability. So let me know what are your thoughts on this in the comment section.